Good morning, and welcome to this session of oral arguments for the Iowa Court of Appeals. My name is Paul Allers. It's my privilege to be presiding today along with my colleagues, Judge Mary Cicchelli and Judge John Sandy. We will be hearing two cases this session. Our first case is Hines Miller versus Teter, case number 24-1879. The appellant, Teter, is represented by Thomas Hillers, and the appellee, Hines Miller, is represented by Jason Springer. All right, then Mr. Hillers, whenever you're ready, you can begin your argument. Counsel?
Your Honors, I believe that our position is sufficiently set forth in the brief that we've filed. I'll do my best to not just regurgitate what's in the brief, but there are a couple of things that sort of get lost in the spotlight of this case, the spotlight being 5 incidents of domestic violence. And I wanted to bring a couple of facts back up to the surface that I do think are important. One is that at the time of this incident, the 5th incident of domestic violence, the child who's at issue in this case was not home. But the other 2 children that Mr. Hines has were home, and there were child endangerment charges filed. So it wasn't as though he's unwilling to commit domestic violence with children around. It was simply that the child wasn't at the house. And
that your position relies primarily on the statutory presumption?
Yes.
And you agree that that presumption is rebuttable?
Yes.
Okay, so then, is your position that it's only rebuttable by showing basically, for lack of a better phrase, reformation of the domestic abuser, right? He has to show that, he's learned his lesson, he's not an abuser anymore because he's taken classes, whatever he's done to show that he's no longer a domestic abuser?
I hope that the Court of Appeals would take this opportunity to make that clear, that the evidence that needs to be presented to rebut the presumption isn't just the statutory factors. That totally dilutes the effectiveness of this presumption. If we're going to just use those statutory factors to rebut the presumption, it needs to be what we find to be reformation of the character defect, which, go ahead.
Explore that position then a little bit. So let's say, taking that position, you've got dad, and let's say he's an unrepentant domestic abuser, okay? Which I think is basically your position here, right? But otherwise, and you might be too young to even catch this reference, but he's Ward Cleaver otherwise, right? He's like perfect dad, right? Checks every box, great dad, but he's a domestic abuser. And then let's say we had mom, and I know this isn't the case, but you had mom who, let's take cases out of our China cases. She's a meth addict. She locks the kid in a cage in the basement without food, water, and toilet for days on end. They live in a rodent-infested, feces-filled house with, knives and guns available to the 5-year-old, and then she goes on benders for, weeks on end and leaves the kid to fend for himself at age 5. World's worst mom, but she's not a domestic abuser. Is your position then, if you take it to its logical conclusion, is in that situation, because of the presumption we got an unrepentant domestic abuser, we should give physical care and custody to mom?
And I think we've already...
Getting around your position then, because it seems to me that then what we're doing is we're weighing the factors, and in this case the factors outweigh in dad's favor despite the domestic abuse.
Yeah, I think the analysis begins with this presumption, and it's not a black and white complete presumption. I think you begin with that. You find the history of domestic violence, which is established in this case, I think. But then, relying on the Ford case from '97, you look at things for reformation. Has he presented any evidence that we believe, one, he's admitted that he has a problem?
Well, there is no such evidence. He's unrepentant. Says, I like being a domestic abuser, I'm going to continue to do it.
And then I think you get to, I think it's the Daniels case, and that's what the Daniels case ended up weighing out and said, there's evidence that mom actually abused the kids, and we find, sitting in equity, that it's actually better for the child to be with dad. That's not the case we have before us.
So if I understand you correctly, then even if you have a non-repentant domestic abuser, we still have to weigh the factors. So referring to the Daniels case, if mom's abusing the kids, we say, okay, that outweighs the detriment of the unrepentant domestic abuser.
Separate analysis. If you have those facts in the record, I think you need to consider them. But we don't have those facts in this record, so.
We don't have much in the way of facts in the record either, as far as like what's going on in mom's house.
So in mom's house, we've got she's consistently lived at this residence. She's stayed with the same partner throughout the entire course of the case. She's raising other kids in an environment where those kids are thriving. What we have on the other side of that scale is dad's moved multiple times.
Evidence in the record that the kids are thriving, other than just a statement. Is there any other proof of that we can find? I mean, because I looked and about 10 pages of transcript testimony was all that she had.
Her testimony as to how the kids are doing, that's right.
Well, not about how the kids are doing, but just about really almost anything that could be going on in her house, like what her job is and where she lives, and that she, you know, there's a significant other obviously in the home that has a job. We don't know much of anything else. A paucity, I think, is what the district court called the situation, a paucity of evidence.
And I think that from our perspective, if we step back and look at someone coming into our court who has 5 domestics, that's a rarity. That's a unicorn in terms of what district court judges, associate court judges, and magistrates see coming in. A third is somewhat rare. I'll admit that a first is fairly common. A third's rare. A fifth almost never happens. It's
To Judge Kelly's question, I think our concern is how do we know this isn't out of the frying pan into the fire situation, because we know almost nothing about mom. And that's a concern, right? That we don't have any information, in part because she has the obligation to prove superior parenting in order to get a change in physical care. And I think the concern is we don't have much information about her.
Yeah, and I think it still needs to be on the balance that what she has produced is sufficient in light of the evidence on the other side. As almost a per se matter of law, he's not qualified to be a parent of this child due to what Chief Justice Cady set out in his opinion, that the impacts on children who are raised in domestic violence.
Counsel, aside from, I read Judge Polking's order a little bit different maybe than my friends do in that I don't think it's as much as a lack of evidence as it is perhaps maybe equipoise, right? Like he kind of is like, they're about equal. So how can you say one's superior if, as in fact, I'll use his words. He says, it appears Ashleah, am I pronouncing that right? Ashleah's testimony that she would continue doing what Javante has as far as schooling and extracurriculars like football, she'd continue. There's no indication from the evidence that one parent communicates better than the other or is more supportive or not supportive of the other. I kind of take his opinion to be more so that he finds that your client just failed to establish that she is able to provide more superior care. So I want to talk about, is it Kaylee? Is that Javante's paramour?
I believe so.
Is it his wife or his paramour? And that was the 5th domestic abuse victim, right, that brought you into the second modification. Did she create the own marks on her neck? How did those marks on her neck come about?
During her examination, she denied that any domestic violence had occurred, and so did Mr. Hines. Then I presented the police body cam video showing that, and she recanted and said, oh, I lied.
Well, but she had indicated, at my reading of the transcript, correct me if I'm wrong, is that she had testified at the modification trial that she actually lied to the cops. Yeah, so she doubled down and said she lied to the cop. She didn't say, I lied in my affidavit, but here today I'm going to tell the truth. Yeah, he did strangle me. Is that right? So you have Kaylee, the paramour, lying at the very modification trial. And is that problematic?
Yes, it is the evidence of an unrepentant domestic abuser. What do we always have? A guy who says it didn't happen, and a victim who's coming in calling the county attorney saying, I want to drop it. It didn't happen. I made it up. It's textbook domestic violence, which our legislator has tried to make clear is powerful, and we don't want kids raised in those environments.
For your time by asking this question, but I guess I'll invoke my privilege as a presiding judge to do that. As I read the court file, the parties have joint legal custody, correct? And when mom petitioned for modification, she asked for a change in physical care, but not legal custody. Is that correct? Okay. How does that impact our analysis in light of the Hines case cited in your brief, which says we don't consider the factors listed in section 598.41 sub 3 when the parents agree to joint legal custody?
I don't think it follows that we shouldn't consider this.
I'm not saying consider it. It's obviously a factor because it goes to the well-being and best interest of the kids. But as far as the statutory presumption goes, that's where the statutory presumption is. And if Hines says we don't consider that, when there's an agreement on joint legal custody, how does that impact what we're doing here?
That when this statute was originally promulgated, back whenever all of us were kids in the 80s, what joint custody was a whole different thing than what it is today. And what they thought they were doing back then isn't what we do today with collaborative divorce, et cetera. And I think primary care, in the decision of primary care, domestic violence and that presumption should certainly apply. And I think the court has the authority to apply it within the primary care consideration, Your Honor.
Thank you. And you'll have 5 minutes in rebuttal, of course, Mr. Hillers. And Mr. Springer, whenever you're ready, you can begin your argument.
Your Honors, may I please the court? Counsel. Your Honors,
Before you get going, we got 10 minutes?
I did see that, Your Honor. I thought we assumed that I had 10 minutes.
Yeah, that's fine. Thank you. All right, I'm sorry, go ahead.
I think you bring up a valid point here. This was a case that was agreed upon beforehand, that it was still going to continue as joint custody. And so one thing that I did not argue in my brief, and again, I don't want to regurgitate everything that we've argued about in our brief itself, but the point is that I don't believe that those factors are relevant. I believe that, yes, I would agree that there's a presumption that needs to be rebutted, but because we are agreeing that joint custody is something that was agreed to by the parties, we're dealing with primary physical care and primary physical care only. And that's why I believe that Judge Polking basically stayed on this.
Counsel, if the mother was provided sole legal custody, could your client have primary physical care?
Not, Your Honor.
So how do you help me track that?
Well, my point is if both parties in agreement with joint custody, and because the presumption pursuant to that code section, it refers to sole custody, and the presumption is required to get sole custody, I just don't think that it's relevant in this case. I think we're dealing.
Been more unreasonable?
Talking about the domestic violence or the presumption? Okay, sorry, go ahead.
So if the mom had been more unreasonable, so to speak, and actually asked for a more aggressive form of remedy prior to trial, she'd be rewarded more now. Is that the line of thinking?
I don't think that, and I understand exactly what you're saying, and my point is that that's not what we're led to believe, though. If that was the case, then I think that this could have been amended. That's not the intent of the legislature to have it like that, because they did require that it was part of the sole custody and not part of the physical care. So I understand what you're saying, but we're left with what we've got for a statute to deal with, and because of that, I think the presumption, we don't even get to there. I think we.
Does the victim of the domestic need to be the mother or the children for purposes of enactment of the statute, the presumption?
So, Your Honor, but I do believe it does. I think we've got to look at how it affects the child, how it affects the children, if the children were involved, if there were other children involved. Now, there's been some dispute whether the other children were involved in this last domestic incident. And when I say incident, I've gone through the record, and I know for a fact that there wasn't 5 convictions here. So we've still got this idea that my client feels like he did not commit 5 different domestic abuse claims. He admitted to the last one. He admitted that he did something wrong. When we get to court, yes, there was some back and forth of what had transpired in that incident. The point is that he did admit to doing this, that Cam was not in the household, and that they did testify in the modification that the other children were not around when any of this occurred. Now,
To be convictions, right? I mean, looking at sub J, we look at whether a history of domestic abuse exists. We look at a number of things. And I guess, first of all, are you challenging the fact that there's a history of domestic abuse here? Okay. But I mean, we look at commencement of 236 proceedings, issues of protective orders, response of a peace officer to the scene of alleged domestic abuse, or the arrest of a parent following response. Given that standard, do you agree that there's 5?
I agree that there's 5 incidents, yes. Okay, so what I mean by that is that it's hard to rebut a presumption or to repent or to do anything as far as making things right or reaffirming that he's a good parent for incidents that are in controversy. That, yes, there was domestic incident, but did my client actually do anything wrong, I guess is the question. And if he did something wrong, how does he repent, or did not do something wrong, I should say. If he did not do something wrong, then how does he repent from that?
I know that Judge Polking found that there was a history of domestic abuse. Fine. Did Judge Polking ever make a finding that the presumption was actually rebutted or not?
I believe he did, Your Honor. And I argued it in my brief. I don't think that, and I would agree with you, if we look through his order, that we cannot find where he absolutely says that it's been rebutted.
He finds that the mother did not carry her burden to show that she was the superior caregiver to justify the modification, but he found a material and substantial change in circumstances had occurred because of what I take to be the unrebutted presumption of domestic abuse history. And I guess I'm left, I know that there was a finding that domestic abuse history occurred. I don't see a finding one way or the other definitively whether or not the presumption was or was not rebutted.
I got 2 things for you, Your Honor. First of all, I believe that he does say that it is substantial, but I don't believe he says it's material. Another thing is that the fact that he doesn't, I think what he's getting at here is he relied on the fact that there was no evidence of superior parent here to provide them with primary physical care.
Presumption. I mean, the presumption to be rebutted, as Mr. Hiller's pointed out, is reformation, right? Things that, in Ford that kind of talked about temporal timing, DAIP classes, kind of what you're doing, action, those types of 4 factors. Help me out there.
With all due respect, Your Honor, I think that my client did provide do the things that he needed to. First of all, he didn't fight the last charge. He admitted that he did a wrong here.
He strangled her?
He didn't admit that he strangled her on the record, and he didn't admit that he strangled her in the court, no. But he did admit that he did something wrong.
What's repentant about, he dodges the first modification action that got started because of a domestic incident, and then he goes out and commits another domestic incident that prompts the second modification action. How does that show repentance?
Your Honor, I think he did everything he was supposed to do called by the court. In other words, for the first incident, he did what he was supposed to do. He admitted to it. He did everything that the court required him to do, which he did. My question, and I don't mean to ask a question for a question, but I don't know what else more he's supposed to do. The last incident.
Significant other, I mean, that'd be a good start.
I agree with you, Your Honor. The point is, the last incident is with, and I think there was some question of whether a paramour or wife. After this occurred, after the no contact order was dropped, not only did they get married and have been living together ever since, but we've got the parent of Kaylee testifying to the fact that he believes that he's changed. He believes he's a good father. He believes that he can be around his daughter. He can be around the children, that he has no concerns of any problems with him ever doing anything like this.
Kaylee's mom is not one to invoke an oral argument when I think she questioned on the record whether or not you have to physically beat somebody to abuse them and different things like that, right? I mean, my concern, counsel, if I'm being in all candor, is I have concerns that whether it's Kaylee's mom or Kaylee, they're still doing the dance with respect to accountability and appropriate boundaries within that home. And isn't that a significant factor when you're looking at primary placement of a child?
I think it's a factor, Your Honor. I think it's one of several factors. And I think Judge Poking brought it up best, that it's not affecting Cam. And while moralistically and the way I feel about this world, yes, I believe it's a significant factor. But in this case, when we're talking about a minor child and the best interest of that minor child, and this minor child, in all reality or in the evidence presented, is doing very well where he's at with primary physical care being granted in my claim.
My next question, because I think there is this concern that given the lack of evidence about what's going on in mom's home and what type of parent she is, given the fact that we seem to have a kid that's doing well in the current placement, it's like, why should we gamble to switch that when we're switching it to an unknown? I think I said out of the frying pan into the fire earlier. But I guess my question is, if there was a concern about mom, like why doesn't she have physical care of another child? Or is there a problem? So is it into the fire if we take kid out of the frying pan type of thing? Keeping within the records, I don't want you to talk about stuff that's not in the record, but why isn't there any evidence that you presented about kind of warts of mom?
I think there was some evidence, Your Honor. First of all, she doesn't have primary physical care or other children. Second of all, she doesn't provide.
And we don't know why, right? I mean, there wasn't evidence that you presented as to why.
Well, and not only that, Your Honor, but I think there's evidence that she has moved around quite a bit, that there was no evidence provided by her paramour of what type of person he was. I think Judge Poking refers to that we don't even know what her paramour is like. There was no testimony of that. I believe that.
And your position is she's got the burden to show she can provide superior care, so it's her burden to bring that in, not your burden to throw dirt at her.
Your Honor, exactly.
Okay. Thank you. Mr. Hillers, whenever you're ready, you'll have 5 minutes in rebuttal.
Thank you, Your Honor. I would say that, just to follow up on my last statements, I do think the court has the authority to adopt the presumption in primary care decisions, and I do believe that just like when we consider the best interests of the child factors, we still have, I believe it's the Winters case, that is a common law decision where we consider additional factors outside of the statute. I believe that in this context.
But he disputes that that we can consider the domestic abuse history. I think the concern comes in as to, is there a presumption, and what does that presumption mean when it says shall outweigh consideration of any other factor, which seems to suggest it's irrebuttable, but 2 sections before that it says it's rebuttable. So, I mean, it's, with no disrespect to the legislature, I mean, it's not a particularly well-drafted piece of legislation. So
Key waters.
Key waters, and it's, and this is, the case kind of highlighting that, the murkiness of this, right?
From a practitioner's standpoint, it would be very helpful to have some clear guidance on what we're to do, because to take off of Judge Sandy's point, am I to take that unreasonable position in every case where domestic violence, where I have evidence of it? Am I supposed to go for sole custody on every single one when the parties on every other factor seem to be getting along and raising this child? And I would say it is very draconian to think that just because of domestic violence, that dad can no longer be involved in the child's life with the exception of visitation. I think that would have even more of a dramatic impact on the child in some circumstances, because what you really want to do is, what I think the court or the legislature really wants us to do is, parlaying off of the late Chief Justice Cady's points and his opinion, you want to take that child out of that environment for most of his life and put him in an environment that doesn't have domestic violence. That's the first consideration. If there's a home that's filled with domestic violence, what we're seeing come out as these 5 is the tip of the iceberg for what's going on in that household. So it is better, as a matter of law almost, to raise the kid in a house where there's no evidence of domestic violence than one where there's substantial evidence of domestic violence.
What's your best pitch for how, you would agree with me that she has the burden to show ability to provide superior care? Yes.
Yeah, I agree.
What's your best case for how she's done that? What has she shown that shows she can provide superior care to dad?
Because it's a balance. It's that his so grossly outweighs hers. She almost by existing as a human being is a better parent than a habitual 5-time domestic abuser. Putting her in court and she can testify, and I would clarify, she does have primary care of one of her children, but as it applies to
At least one that she doesn't? Is that?
doesn't, and then this child at issue in this case, and what I would say is,
She have 3? Okay, so she's got physical care of one, doesn't have physical care of another, and then doesn't have physical care of the child at issue here. Okay, thank you.
think of how, think of the challenge that she has being the victim of the first 2 incidents of domestic violence, and now she's put on the modifications for these, that she only has this child every other weekend. Think of how hard it is to marshal evidence in with really your only witness is the child. She's almost forced to try to get evidence out of the child of what's going on in the other household. And then what she can do to show she's a superior parent, she only gets an opportunity twice, a Saturday and a Sunday every other week, to show that she's a better parent.
Child is doing well in the current placement?
I would bet you that the child is resilient and the child is getting by.
Okay, so what's the answer to my question?
I think that no matter what, a child raised in a home with domestic violence is not doing well.
Okay, but looking at the evidence, do we have evidence that the child is not doing well, other than I understand your belief, and I get that. That's part of the horrific nature of domestic violence, is it does have that kind of subterranean, potential impact. But as far as actual evidence, do we have evidence that the child is not doing well in its current placement?
It's a good question, and I think in a sort of run-of-the-mill level family law case, yeah, we have the evidence in the record that the child's doing fine.
Thank you.
Thank you.
Thank you, counsel, for both sides, for your efforts in your briefing and your arguments here today. That's been very helpful, and we'll consider this matter submitted, and we'll have a ruling out as soon as we're able. Thank you.